Ladies and gentlemen, our chief guest is arriving in the next 5 minutes. I request you all to kindly settle down.
Ladies and gentlemen, may I request you to kindly rise as the esteemed guests and dignitaries arrive. The program will start in 5 minutes. I kindly request everyone to keep your mobile phones on silent mode.
Namaskar. A very good morning and a warm welcome to one and all present here.
I am Advocate Shreya Patnaik, and alongside me is Advocate Trisha Sharsi. We are members of the prestigious and historic Orissa High Court Bar Association, and it is a proud privilege to host today's symposium.
We are greatly privileged and deeply humbled to have amongst us today Honorable Shri Justice Surya, Chief Justice of India as the chief guest, and Honorable Shri Justice Harish Tandon, Chief Justice of Orissa High Court as the chief speaker. It gives me great pleasure to mention that we are graced by the presence of distinguished guests of honor, Senior Advocate Shri Pitambar Acharya, Advocate General of Orissa, Shri Sitanshu Mohan Dwivedi, Advocate and Chairman Orissa State Bar Council, and Senior Advocate Shri Manoj Kumar Mishra, President, the High Court Bar Association Orissa, who will be presiding over this symposium.
Today, on 14th December 2025, we are assembled here for the symposium on ensuring justice for the common man, strategies for reducing litigation costs and delay, organized by the High Court Bar Association Orissa. This symposium has brought us all together for the profound insights of our chief guest, chief speaker, and distinguished guests. We are also graced by the presence of honorable judges of High Court of Orissa, former judges, esteemed Chief Secretary, respected Director General of Police, illustrious bureaucrats, revered seniors, judicial officers, learned members of the bar, and officers of the registry. We extend our gratitude to the media personals present here, students, academicians, participants gathered from across the state, ladies and gentlemen in the audience, for their presence. We extend our heartfelt thanks to viewers who are participating in this event via the YouTube live stream. We shall now embark on today's deliberation. May I humbly request Senior Advocate Shri Manoj Kumar Mishra, President, Shri Siddharth Das, Vice President, and Shri Avijit Patnaik, Secretary, High Court Bar Association of Orissa, to conduct Honorable Chief Justice of India, Shri Justice Surya, and Honorable Chief Justice of Orissa High Court, Shri Justice Harish Tandon, to the dais. May I now request Mrs. Annapurna Panda and Mr. Surendra Kumar Das to conduct Shri Pitambara Acharya, Senior Advocate and Advocate General of Orissa, our distinguished guest of honor, to the dais. I request Shri Saubhagya Kumar Das to kindly conduct Shri Sitanshu Mohan Dwivedi, Advocate and Chairman, Orissa State Bar Council, to the dais. Thank you for sparing your valuable time to grace us with your presence.
Access to justice is fundamental to the rule of law. However, prolonged timelines and escalating litigation costs continue to erode their faith in the legal process and the judicial system. The convention of the highest officers of the bench and eminent legal luminaries of the bar stands as a testament to our dedication for practical and enduring reforms. May this hall reflect the ethos of the bench and the bar, intellect, excellence, and a collective commitment to constitutional values. We will now have the state anthem of Odisha, Bande Utkal Janani. Everyone is requested to rise for the state anthem. Thank you all. We will now proceed to the ceremonial lighting of the lamp and Pushpanjali to Mahaprabhu Jagannath. I humbly request Honorable Shri Justice Suryakant, Shri Justice Harish Tandon, Senior Advocate Shri Pitambara Acharya, Advocate Shri Sitanshu Dwivedi, Senior Advocate Shri Manoj Kumar Mishra, Advocate Shri Siddharth Das, and Advocate Shri Avijit Patnaik to initiate the ceremonial lamp lighting.
Tamaso ma jyotirgamaya mrityorma mrutangamaya Om Shanti Shanti Shanti.
May Mahaprabhu's divine blessings illuminate the path of our today's deliberations. Next, we have the presentation of flower bouquet as a token of gratitude and respect. I request Advocate Padmalaya Mahapatra, Joint Secretary, High Court Bar Association, Orissa, to present the bouquet to our Chief Guest, Honorable Shri Justice Surya KANT. I request Advocate Abhijit Das, Assistant Secretary, to present the bouquet to our Chief Speaker, Honorable Shri Justice HARISH TANDON. I request Advocate Sapan Pearl, Assistant Secretary, Library, to present the bouquet to our guest of honor, Senior Advocate Shri Pitambar Acharya. I request Advocate Saubhagya Das, Executive Body Member, to represent the bouquet to our guest of honor, Advocate Shri Sitanshu Dwivedi. I request Dr. Surendra Das, Executive Body Member, to present the bouquet to Senior Advocate Shri Manoj Kumar Mishra. I request Advocate Annapurna Panda, Executive Body Member, to present the bouquet to Shri Siddharth Das. I request Advocate Ranjan Kumar Behra, Executive Body Member, to present the bouquet to Advocate Shri Avijit Patnaik. Please be seated.
May I now call upon our dynamic and visionary Secretary of the High Court Bar Association, Advocate Shri Avijit Patnaik, for the Secretarial address.
Good morning to all. On this momentous day of 14 December 2025, I, being the Secretary of the High Court of Bar Association, Odisha, with all humility and gratitude, welcome His Lordship, Honorable Chief Justice of India, Sri Justice SURYA KANT. I also take the honor and privilege to welcome Honorable Chief Justice of Odisha High Court, Sri Justice HARISH TANDON. I welcome Honorable Judges of Odisha High Court and Honorable former Judges of Odisha High Court. I also welcome our revered Advocate General, Sri Pitambar Acharya Sir. I also welcome Sri Manoj Mishra, Senior Advocate and President of High Court Bar Association. I also welcome our most lovable Chairman, Sri Sitanshu Dwivedi, Chairman of Odisha State Bar Council. I welcome the respected senior advocates of the bar in the gathering. I also welcome the members of the registry and my dear colleagues and members of legal fraternity present here. It is a profound honor to keep the introduction to this present symposium on a compelling theme of ensuring justice for common man and strategy for reducing litigation cost and delays. My aim is today to join this deliberation to confront the structural obstacles that impede justice and to work towards a future where the pursuit of justice does not exhaust the resources or the patience of those whose system is meant to protect. In this contest and on this occasion, I am privileged to welcome our chief guest, the Honorable Chief Justice of India, Justice SURYA KANT. His Lordship was born in 1962 at Hisar, Haryana, in a middle-class family. He went on to graduate from Government Postgraduate College, Hisar, in 1981. He has earned the bachelor's degree in law in 1984 from Maharishi Dayanand University, Rohtak. My Lord started practicing at the District Court Hisar in 1984. He then shifted to Chandigarh in 1985 to practice in Punjab and Haryana High Court. His Lordship is specialized in constitutional service and civil matters. During his tenure as an advocate, His Lordship has represented a number of universities, boards, corporation, banks, and also the High Court itself. His Lordship earned the distinction of being appointed as the youngest Advocate General of Haryana on 7 July 2000. My Lord was designated as Senior Advocate in March 2001. His Lordship held the office of Advocate General of the State of Haryana till his elevation as the permanent judge to Punjab and Haryana on 9th January 2004. His Lordship assumed the charge of the Chief Justice of the High Court of Himachal Pradesh with effect from 5th October 2018. His Lordship was elevated as Judge of Supreme Court of India on 24th May 2019. His Lordship then was sworn in as the Honorable Chief Justice of India on 24th November 2025. His Lordship, being the Honorable Judge of Supreme Court of India, was part of more than 300 benches on a wide range of constitutional, criminal, and civil and administrative issues. His Lordship's recent intervention and judicial vision embodies precisely what this symposium stands for, and also has instilled renewed confidence and energy among the younger members of the bar. In his landmark judgment of Arvind Kejriwal versus CBI, His Lordship held that bail cannot be denied on the ground of mere procedural technicalities. His Lordship was part of a constitution bench of Supreme Court that upheld the abrogation of Article 370, the provision that gave special status to Jammu and Kashmir, which is regarded as one of the most significant constitutional rulings in the recent Indian history. This action of His Lordship reflects a deep and consistent commitment to render justice that is swift, meaningful, and accessible, especially for those suffering to delay, neglect, or systematic inertia. I am equally enthralled and honored by presence of Honorable Sri Justice HARISH TANDON, Chief Justice of Odisha High Court, whose leadership has energized the efforts within our state to reduce arrears, promote alternative dispute redressal, strengthen mediation and conciliation, and bring digital practices to the forefront of court administration. I am also honored by presence of Sri Pitambar Acharya, Senior Advocate, Learned Advocate General, Odisha, our guest of honor. And other guest of honor, I welcome Sri Sitanshu Mohan Dwivedi, Chairman, Odisha State Bar Council, guest of honor. This symposium is a reminder of a simple truth, that justice must remain close to the citizen it serves. I would also remind myself that we as the members of the fraternity also have an onerous responsibility in this regard. With this, I take a leave. Jai Jagannath. Thank you, sir.
Thank you, sir, for that gracious opening. Every gathering finds its meaning with a voice that sets the tone and anchors us to the purpose. I am honored to invite the most beloved personality of our legal fraternity and inspiration, a kind mentor and a father-like figure to most of us present here. Senior Advocate Shri Manoj Kumar Mishra, President, High Court Bar Association, to deliver the inaugural address.
Jai Jagannath. Good morning all. Honorable Chief Justice of India, Chief Justice SURYA, our esteemed Chief Guest, Honorable Chief Justice of Odisha High Court, Chief Justice HARISH TANDON, our Chief Speaker, Honorable Judges of High Court of Odisha, our distinguished guests of honor, Sri Pitambar Acharya, Senior Advocate and Advocate General, and Sri Sitanshu Mohan Dwivedi, Advocate and Chairman, Odisha State Bar Council, Sri Siddhartha Das, Vice President, High Court Bar Association, Sri Abhijit Patnaik, Secretary, High Court Bar Association, Office Bearer of High Court Bar Association and various bar associations present, former judges, Chief Secretary, DGP, bureaucrats present, and other senior dignitaries, senior advocates, Registrar General and officers of the registry, judicial officers, members of legal fraternity, friends on media, and my dear students. Ladies and gentlemen, today is a special day for the legal fraternity of Odisha. We are deeply honored that Honorable Chief Justice of India has agreed to grace the occasion as our Chief Guest to deliberate on a critical bottleneck in the judicial machinery. On behalf of the High Court Bar Association of Odisha, it is my proud privilege to welcome you all to this symposium on ensuring justice for the common man, strategies for reducing litigation of costs and delays, which has been chosen by my Lord Chief Justice himself. Allow me to first formally and heartily congratulate Honorable Justice Surya Kant on behalf of the entire legal fraternity and people of Odisha upon assuming office as the 53rd Chief Justice of India and his lordship's first trip to our High Court, to our place today as Chief Justice of India. Your Lordship, we are deeply honored and privileged by your gracious presence amongst us. Your Lordship's elevation has filled lawyers across the country with optimism and enthusiasm because of the clarity with which your Lordship has already articulated the priorities of your tenure. It lends immense credibility and legitimacy to this initiative of the bar that seeks to engage constructively with one of the most pressing concerns of our justice delivery system. Your Lordship's presence is not merely ceremonial, it symbolizes the bench's willingness to dialogue and reform its enduring partnership with the bar in making justice accessible to all. The selection of today's theme itself speaks volumes about your Lordship's vision and predisposition towards a justice delivery system that is more inclusive and citizen-oriented, one that emphasizes accessibility, affordability, and efficiency over procedural complexity and delay. This orientation reflects a deep empathy for the ordinary litigant whose faith in the rule of law depends on both fairness and timeliness. Your Lordship's true devotion for Mahaprabhu Lord Jagannath and deep affection for Orissa's sacred traditions have acquired deep appreciation in your hearts. Allow a word of personal gratitude. I had the privilege of meeting Honorable Chief Justice of India, as His Lordship then was, for the first time on 18 September. Despite an extremely demanding, His Lordship has given only 5 minutes time, but despite an extremely demanding schedule, your Lordship extended me a warm hospitality that I will never forget and will remain ever obliged. And His Lordship, for allowing me to full 20 minutes hearing patiently about our concerns and without any hesitation expressing willingness to visit as our guest and guest the symposium. For the first instance, His Lordship readily agreed that yes, I would love to go to your place. Thanks for the invitation. So I am really personally again to express my obligation to His Lordship. Again on 19th October, your Lordship, I met your Lordship at a mediation conference held in Bhubaneswar. Your Lordship not only reaffirmed your consent, but also made a thoughtful request that, if possible, the symposium be preponed by a week so that it could be accommodated with your hectic schedule. That one remark was a clear message as to how seriously your Lordship views engagement with bar. On 29 November, the Bar Council of India held a felicitation ceremony in New Delhi for His Lordship as 53rd Chief Justice of India. I was lucky to be invited, and your Lordship confirmed your plan to visit Cuttack. For our bar, this journey from an idea in Cuttack to an assurance in Delhi and finally to this hall will remain part of our collective institutional memory. In this very first public statement, after assuming office, your Lordship had sent a powerful message that Supreme Court is first and foremost a court for the common man. You have spoken of having no time for luxury litigation. That is a very serious word His Lordship has said. Your Lordship has made a commendable candid disclosure of willingness to sit in court till midnight for even the common and poor litigants, not for luxury litigants. His Lordship will sit for 12 o'clock for poor and needy litigants. That speaks of His Lordship's mind and attitude. If that is what it takes to ensure that last row receives the equitable justice. Equally inspiring is the Lordship's consistent focus on structural reforms, national judicial policy to reduce delay, and an insistence that access to justice must not become a luxury commodity available only to the well-connected. You have drawn attention to the distress of farmers and the poor. Because he is from a farmer family, so he has given much importance to the farmer cause, and to the cost of litigation, and to the need to equip our courts for new forms of dispute. For those of us who believe that the Constitution lives most truly in the lives of the most vulnerable, this agenda resonates deeply. Today's gathering is a reaffirmation by both bench and bar of our shared responsibility to ensure that constitutional promise of justice is meaningful for every citizen, regardless of means of situation. I would like to make another mention that under your Lordship's Honorable Justice Harish Tandon's leadership, Our High Court has taken notable steps in improving case management, case flow, monitoring, litigation management system, ADR mechanism, strengthening institutional discipline, and encouraging young members of the bar. My sincere thanks also to Sri Pitambar Acharya, my younger brother, Learned Advocate General for the state of Odisha, who joins us as guest of honor. His office stands at the intersection of government policy and judicial scrutiny. The Advocate General's insight on how the state views litigation, particularly in matters of public interest, taxpayers' money, litigation strategies, and governance will enrich our discussion. And one thing I'll tell you, after Mr. Pitambar Acharya joined as Advocate General, he has reduced the cases in Supreme Court by thousands. Not only hundreds, but thousands. Justice Suryakant will, I think, will surely agree to it. It is with this sense of duty and utmost humility and that I place before your Lordship a matter of urgent concern. Our High Court today, this is a very important submission before my Lord. Your Lordship, our High Court today carries a staggering burden of over 1.5 lakh pending cases, including more than 63,000 writ petitions, over 6,000 bail petitions, nearly 13,000 criminal appeals, besides numerous decade-old civil litigations, while nearly one-third of the sanctioned strength of 33 judges remains vacant, with only 20 honorable judges striving beyond measure to keep wheels of justice moving. The strain upon the institution is immense. And most of the judges are sitting beyond 5 o'clock also to clear up the backlog. But the backlog is so huge. Actually, we are really obliged to our lords who have taken, even some judges, honorable judges are sitting up to 6 o'clock also to clear the backlog. So in this context, we earnestly pray that steps may kindly be taken for the early filling of all vacancies, for reasonable enhancement of the sanctioned strength, and for timely recommendations well in advance of the requirement scheduled in 2026. Because 2026 we are going to face at least 4 vacancies. We may also make a humble request that deserving judges from this High Court may be considered for appointment as Chief Justice of various High Courts, thereby ensuring fair representation, institutional continuity, and recognition of their merit. None having been so appointed since the tenure of Honorable retired Dr. Justice B.R. Sarangi as Chief Justice of Jharkhand High Court ended in July 2024. Since last about 1 year, 4 months, we don't have any Chief Justice in the High Court. So this is also our prayer to Honorable Chief Justice to consider this aspect. Likewise, may consideration also be given to the elevation of judges from this High Court to the Supreme Court, restoring the regional balance and diversity. Last representative Honorable CJI Deepak Mishra. And we have at least 3 CJIs from Odisha in Supreme Court. And many land by Justice Honorable, many judges, because of the short of time, I am not naming all the honorable judges. But certainly, since last 7 years, we don't have any representation before the Honorable Supreme Court. It is also our appeal to the Honorable Chief Justice of India to consider this aspect. These are not mere administrative concerns, but heartfelt prayers in the spirit of Article 21 to uphold the constitutional promise of speedy justice, to bridge the widening gap of inequality, and to sustain the faith of the common man in this great institution of justice. We are presenting a memorandum in this regard for our Lordship's consideration. We will present memorandum to the memorandum of given the details, and we will present memorandum to His Lordship. His Lordship may excuse us for disturbing His Lordship, but in this sense, today's conversation is a pivotal exchange between the bar and bench on how we as a community, lawyers, judges and scholars respond to the challenges. I am also grateful to Sri Sutanshu Mohan Dwivedi, Chairman of Odisha State Bar Council, who has joined us as a guest of honor. On behalf of the High Court Bar Association of Odisha, and in my capacity as this President, I extend warm and cordial welcome to each one of you present here today, the bench, respected bureaucrats, learned seniors, young practitioners, students, the media, and our guests. Your presence is a statement that the legal community of this country is ready to confront the challenges and bring about a revolutionary change together. Most of all, I, with folded hands, once again welcome Honorable Chief Justice of India to Odisha. We look forward to listening to Your Lordship's thought-provoking words and erudite guidance, and to draw strength from your unwavering commitment to the poorest litigant, to the independence of the judiciary, and to the constitutional promise of justice for all. Thank you all. Thank you.
Thank you, sir, for steering this gathering with your thoughtful words. We now proceed to the addresses by our distinguished guests of honor. First, may I invite esteemed Shri Sitanshu Mohan Dwivedi, Advocate and Chairman, Orissa State Bar Council, to address this august gathering.
Welcome to everybody. Jai Jagannath. Sorry for inconvenience. Welcome to everybody. Jai Jagannath. Honorable Chief Justice of India, Justice Suryakant, Honorable Chief Guest, Honorable Chief Justice of High Court of Orissa, His Lordship Justice HARISH TANDON, Honorable Chief Speaker, Honorable esteemed companion judges, Honorable Advocate General, Guest of Honor, respected President, Secretary, and all executive body members, Honorable Bar Council members, respected judicial officer, registry officials, respected senior advocates, colleagues of the bar, distinguished scholars and jurists, print media and electronic media, ladies and gentlemen. Law is unclear, needs clarity. Law is to be used than to be misused. Law is to be interpreted than to be misinterpreted. Law is to be understood than to be misunderstood. Before my deliberation, I repress by memory our Honorable President, along with some of our Bar Council members, had occasion to participate the grand felicitation ceremony arranged by Bar Council of India at New Delhi, wherein our Honorable Chief Justice Mr. Suryakant sir has rightly expressed view who told bench and bar are two sides of same coin. Bench and bar arise from same DNA, which inspired me to share, unless until the bar would be educated, unless until the bar member would be digitally, literally, academically sound, no, it is inconvenience to pronounce effective judgment. Judiciary is temple of justice. The act of lawyers are act of priests to distribute justice. My Lord Chief Justice has rightly viewed, unless until the bar, who is the mother, product of bench, would be educated academically, then effective judgment cannot be pronounced. So before initiation my deliberation, before going to the topic, strategy for reducing litigation cost and delays, I would not like to repeat the legitimate grievance put forth by our Honorable President, Manoj Mishra, Senior Advocate. The strategy for reducing litigation cost and delay is not only confined to the quality of lawyers. It is not only confined the cost imposed upon the lawyers. It extends to the infrastructure. It extends to the fill-up of judges, presiding officer in different stations, and also it extends to educate academically to each lawyer for the distribution of justice. It is a privilege to stand before this august gathering today in a forum dedicated to reflecting upon ever-evolving landscape of constitutional rights and corresponding responsibilities that animate and sustain our democratic framework. Such occasions remind us that Constitution is not a static manuscript, it is living, breathing instrument. My sincere request to each advocate should have gone through at least Constitution of India. Each advocate should have gone through at least Advocate Act regarding professional ethics. Each advocate should have convenient to the digital operation nowadays which is required. We have good experience in the COVID, at the time of pandemic, COVID-19. To understand this balance, take our very own courts of law, The digital age has also transformed our courts and practice of law. Since the COVID-19 pandemic, virtual hearing, digital filings, and online access to proceedings have made justice more accessible than before. So we, the learned advocate, should have consultant with the digital operation, and we should be promised to give justice to the litigants by ventilating legitimate grievance of litigants. I would not extend my deliberation more because we are enlightened to hear from our honorable chief guest. As we conclude, let us remember that the future of free speech will not be determined by technology alone. It will be determined by how the law responds, how society adopts, and how responsibly we exercise freedom we cherish. But what must remain constant is the commitment that is to freedom remains meaningful, dignity remains protected, and democracy remains vibrant. In doing so, we honor not only the letter of our Constitution, but also its spirit, a spirit that continues to be shaped and safeguarded by jurists. Thank you to everybody. Jai Jagannath.
Very well said, sir. Thank you for your insightful views. I now invite one of the most versatile personalities and captivating speakers of our personality, Senior Advocate Shri Pitambaracharya, Advocate General of Orissa, to enlighten us with his insightful words.
Jai Jagannath. The star attraction of this august gathering, the top man of the Indian judiciary, a man coming from the grassroots, what many of us call the first generation lawyer, the son of a school teacher, adorning the highest seat of Indian judiciary, my Lord Honorable Mr. Justice SHRI KANT, the chief guest of this morning symposium, my Lord Chief Justice, Honorable Justice Tandon, President Mr. Mishra, Secretary, Vice President, Chairman of the State Bar Council, Orissa, esteemed judges of Orissa High Court, my esteemed senior colleagues, members of the press, electronic and print both, officers of the government, members of the High Court Registry, Honorable retired judges of the High Court sitting in my front, ladies and gentlemen. It is not an occasion for me to address. Incidentally, the honor which they have given me, guest of honor. Neither there is any word speaker is associated with my seat here, nor should I stand as a stumbling block between you, the august gathering, and the star attraction of today's symposium, the Honorable Chief Justice of India, who has come to share his long-standing views both in the bar and the bench. As a glorified member of the bar and as a dignified judge of the bench. Friends, I came to this post at the age of 59. And my Lord Justice SURYA KANT became the Advocate General of Haryana at the age of 39, 20 years earlier to me. So therefore, whatever I speak here about my office, Certainly, I think it would be ridiculing myself. But this much I can say, with the short experience which I have shared with His Lordship during last few days after assumption of this office, the first interaction, apart from the courtroom, was in May 2025 this year in New Delhi. The Attorney General was hosting a mediation conference, what they styled the first mediation conference in New Delhi. My Lord Justice SHRI, as you all know, as an exponent of the mediation in the country, as a champion for imparting justice to the needy and the poorest, was chairing one of the sessions in New Delhi with the co-chair, Madam Justice Nagaratna. I carefully listened to His Lordship's 1 hour-long deliberation on how justice should be dispensed to the common man at the shortest and the earliest, and that too with the accessible means. The Mediation Act 2023, which is a step forward in this regard, has created, and in my perception, what I see the future of litigation in the country may be the future of our nation. My Lord Justice SURYA would highlight on how the justice system would reach the grassroots, the needy and the poorest, and his elaborate discussion on the topic would definitely enlighten each one of us. I will not go deep into that. But this much I can say, so far the litigation policy of a state is concerned, as the highest law officer of the state, I can share with all of you, during last and 1.5 years of my tenure in this office, my first endeavor was to lessen the litigation of the state. Whenever pendency, I cannot say much. Most of my esteemed judges are sitting on my sitting in my front, and it is a coordinated effort between the bar and the bench how to mitigate the long-standing dispute and resolve this issue for reducing the burden of the litigation. But so far, the contribution to increasing litigation part is concerned, in a nutshell, I can tell you, the biggest challenge before a state is how to minimize litigation through the executive action. And I find most of the litigations, say not less than 90%, save and except the commercial and the private disputes, are directed against the state. And there is a dogmatic concept in the mindset of the bureaucrats, which most of my friends are sitting here, they are present here, that the state is losing. The state is losing the litigation. I wanted to clarify the doubt that, dear, look, state never loses a litigation. State is for the people, of the people, and by the people, and it is the people who have formed the state, and the state never loses a litigation. You'll be surprised when none other than Mr. Nani Palkiwala, I had an occasion to go through that letter. When Mr. Suli Sarabji became the Attorney General of the country, he made a public statement, and I will try to uphold the public rights system, the human rights. And Nani Palkiwala, in his eloquent language, way back in 1979, I think, had written a very beautiful letter. To quote Nani Palkiwala, this is not my language, he had written in his letter addressed to Soli Sarabji, Mr. Soli Sarabji, the then Attorney General, the greatest glory of the Attorney General is not to win cases for the government, but to ensure that justice is done to the people of the country. In the United States, this is very important, in the United States, the motto of the Justice Department, carved into the rotunds of the Attorney General's office, is the United States wins its case whenever justice is done to one of its citizens in the courts. See the spirit. The greatest democracy of the world promotes into the rotunds of the Attorney General's office that when a citizen gets justice in the courtroom, that is the glory of the nation. I wish this symposium, the deliberations, and the insights which will come out, that would definitely send a message very clearly and loudly that the state never loses, it is the citizen who wins in the courtroom. Thank you very much.
Thank you, sir, for your illuminating address. One of the most beautiful traditions of the bar is to honor those who have walked this path before us. Today, we felicitate learned advocates who have completed more than 50 years of practice, a truly remarkable milestone. Their lives in law are living commentaries on dedication, resilience, and professional excellence. We humbly request our chief guest and our chief speaker to kindly do the honors of felicitating them. We request Senior Advocate Shri Bijay Krishna Mahanti to come forward for the felicitation. Shri Sanjit Das and Shri Lalitendu Mishra are requested to kindly accompany Shri Mahanti. Shri Mahanti has previously served as the Advocate General of the state and is a former president of this High Court Bar Association. He is not only the most senior advocate of this bar, but has also completed 50 years since his designation as a senior counsel. Due to paucity of time, we request Advocate Dipti Ranjan Mahapatra, Smruti Das, Raj Bhusan Das, Jagannath Mahanti, Sanjay Das, and Mahendra Jena to accompany the senior members whose names are being announced collectively.
Shri Bhakta Hari Mohanty, Senior Advocate. Shri Durga Charan Mohanty, Senior Advocate. I request the audience to please take their seats. Shri Narasingh Patra, Advocate. I request everyone to kindly sit down. Shri Guru Prasad Mohanty, Advocate. Shri Braja Sundar Das. Shri Jagannath Patnaik, Senior Advocate. Shreya. Shri N.C. Pati, Senior Advocate. Shri Darpahari Dhala, Advocate. Shri Satya Sundar Das, Advocate. I request the audience to kindly take their seats. Shri Satya Sundar Das, Advocate. Shri Basudev Panda, Senior Advocate. I request all the dignitaries to kindly come back to the stage. I repeat, kindly conduct the dignitaries back to the stage. Darpahari Dhala, Advocate. Shri Jagannath Patnaik, Senior Advocate. I request Shri Shri Jagannath Patnaik, Senior Advocate, Shri Basudev Panda, Senior Advocate, Shri Bankim Charan Das, Advocate, Shri Surendranath Kaura, Advocate, Shri Satya Sundar Das, Advocate, I repeat the names. Shri Bhaktahari Mohanty, Senior Advocate, Shri Durgacharan Mohanty, Senior Advocate, Shri Narasingh Patra, Advocate, Shri Guru Prasad Mohanty, Advocate, Shri Braja Sundar Das, Shri Jagannath Patnaik, Senior Advocate, Shri Darpahari Dhala, Advocate, Shri Satya Sundar Dhala Das, Advocate, Shri Basudev Panda, Senior Advocate, Shri Bankim Charan Das, Advocate, Shri Surendranath Kaura, Advocate,
having dual responsibility of practicing the bar and agriculture. Excellent. Heartiest congratulations, sir, and all the best.
Shri Shaktidhar Das, Senior Advocate, Shri Surya Narayan Satpati, Advocate, Shri Mahitosh Sinha, Advocate. Shri Durga Prasad Sahu, Advocate, Shri Dhirendra Kumar Mahapatra, Advocate, Shri Vidyadhar Mishra, Senior Advocate, Shri Chinnari Ananda Rao, Senior Advocate, Shri Narayan Prasad Parija, Advocate. Shri Shrikanta Kumar Nayak, Senior Advocate. Shri Jayant Kumar Ratha, Senior Advocate. Shri Sarat Kumar Gajendra, Senior Advocate. Shri Santosh Kumar Patnaik, Senior Advocate. Shri Madhusudan Ponda, Advocate. Shri Dayanidhi Mohanty, Advocate. Shri Phani Bhushan Ratha, Advocate. Shri Uma Ballav Mohapatra, Senior Advocate.
All the best. All the best, sir, and 30th conference. Sir. Election law is a very tough law, very technical law. Must be an expert in CEDAW. Person needs stalwarts like you. All the best to you, sir.
sir.
We call out Shri Ashok Kumar Mishra, Senior Advocate. Shri Aditya Narayan Mishra, Advocate. Shri Netaji Sabyasachi Ghosh, Advocate. You will always remain Heartfelt congratulations on 5 decades of distinguished lawyering, marked by unwavering dedication to justice. I call out Shri Rudananda Tripathi, Advocate. Shri Surya Prasad Chaudhary, Advocate. Sir, your enduring legacy inspires generations of advocates in constitutional arenas. In absence of the senior members to be felicitated, I request a family member or associate to come forward and receive the award on their behalf.
All the best wishes.
We heartily congratulate all the senior advocates being felicitated today for completion of 50 golden years of their practice. I request all the dignitaries to kindly take their seats. Thank you all. The judiciary is not only a guardian of rights in the courtroom, but also must act as a role model for holistic well-being. The All India Judges Badminton Championship 2025 brought together judges from across the country celebrating fitness, camaraderie and sporting spirit. Honorable Chief Justice Shri Justice Harish Tandon, Honorable Miss Justice Savitri Rotha, Honorable Shri Justice V. Narasinghe, and Honorable Shri Justice Sibasankar Mishra had represented Orissa High Court in the 2025 tournaments. May I humbly request Honorable Miss Justice Savitri Rotha, the winner of Women's Singles, to join us on the stage for felicitation. I humbly request Honorable Shri Justice V. Narasinghe to join us on stage for the felicitation. Honorable Miss Justice Savitri Rotha and Honorable Shri Justice V. Narasinghe were the winners of mixed doubles.
Thank you, Your Lordships. The legal fraternity is not only about arguments and affidavits, it is also about art, culture, and shared memories. May I invite Advocate Shri Sanjay Kumar Mahapatra. May I invite Advocate Shri Sanjay Kumar Mahapatra to step forward to be felicitated by our chief guest for his creative contribution to every event at the bar. I request Justice Sivasankar Mishra to join us on stage for felicitation.
I request all the honorable judges of our Orissa High Court to please move to the front row. This is a request from the Honorable Chief Justice of India.
I request our Honorable Chief Justice of Orissa High Court to be felicitated. Chief Justice of Orissa High Court, Honorable Justice Harish Tandon, to be felicitated for his participation in the Badminton Championship. May I now invite Advocate Shri Sanjay Kumar Mahapatra to step forward to be felicitated by our chief guest for his creative contribution to every event at the bar. Without further ado, I request Senior Advocate Shri Manoj Mishra, President, and all office bearers of the High Court Bar Association to come forth for the felicitation of Honorable Chief Justice of India, Shri Justice Surya Kant, Honorable Chief Justice Shri Justice Harish Tandon, Senior Advocate Shri Pitambar Acharya, Advocate General of Orissa, and Advocate Shri Sitanshu Dwivedi, Chairman, Orissa State Bar Council, with memento as a humble token of the bar's respect and gratitude. I also request the office bearers of Orissa State Bar Council to come forward to felicitate our guests. I also request senior advocates of Orissa High Court, presidents and secretaries of the Bhubaneswar Bar Association, CUTTACK Bar Association,
I request the senior advocates to kindly felicitate the Honorable Chief Justice Shri Harish Tandon.
I also request the President and Secretaries of the Bhubaneswar Bar Association, CUTTACK Bar Association, Criminal Courts Bar Association, CUTTACK Bar Association, request Board of Revenue Bar Association, CUTTACK Tax Bar Association, Income Tax Appellate Tribunal Bar Association to join us on stage for the felicitation.
Board of Revenue Bar Association. Criminal Courts Bar Association.
CUTTACK Tax Bar Association, Income Tax Appellate Tribunal Bar Association, CUTTACK,
Thank you all. Renowned for his expeditious disposal of cases, accelerating public interest litigations, conferring fair opportunity to litigants, empathy towards poor, deep commitment towards the welfare of legal fraternity, and pioneering directives on cost-effective adjudication, both in Calcutta High Court and Orissa High Court, Honorable Justice Shri Harish Tandon's visionary approach continues to inspire reforms that reduce litigation burdens across benches he has served. It is my profound privilege to invite your Lordship to share his valuable wisdom and guidance.
The Honorable Mr. Justice KANT, the Chief Justice of India, my esteemed brother and sister judges of the Orissa High Court, the Advocate General of the state, the President, Vice President, and the Secretary of the Orissa Bar Association, the other members who are present, my former senior colleagues on the bench, the former judges of this court, the senior advocates, the distinguished guests, the law students, the media peoples, ladies and gentlemen. It is a great privilege and honor to stand here as a testament to this momentous occasion when the Chief Justice of India has really graced this particular symposium and is really championing the cause of reducing the pendency, which is really grappling everywhere in the docket of the court across the country. Not only the reduction, but also the timely justice to be extended, and how the cost can be minimized so that it can become the access to all the common man, more particularly the poor, economically downtrodden persons who really have no means to access the justice. The expression access of justice is not simply an abstract word, but have to be embraced in every system. When we talk about a justice, it not only ensures the fair and a transparent manner of adjudications, but also a justice to the satisfaction of a common people. When the court systems have been introduced, it is introduced with the avowed object of ensuring that the common people can redress their grievance, have the adjudications of their dispute, and may go with the sense of satisfactions that the system which is put in place has really done well. What happens when the docket is exploded with the menace of the heap of cases which is mounting day by day? The multiple factors that really plays a lot in this regard. And definitely one of the factors is, I always believe that every judge or every system must have the time management system to be put in place. I have been going through the statistical data which has been provided to me 2 days before by my registry. I was just surprised to go through the data where I find that so far as the civil cases are concerned, it is taking more than 1,300 days to get it disposed of. This is really an alarming. The criminal cases are getting nearly the same amount of days to have it disposed of. We have to ponder upon, we have to introspect, we have to think that what best way we can do and have the reduction of the cases and a timely disposal thereof. I must share my experience which I gathered while coming into the system from the day one when I started my journey as a lawyer and then on the bench. Most of the litigations are against the government or the state. The revered learned Advocate General very aptly said that it is not a litigation against the state. It is really a justice to be given to people of the country. So definitely it is in such pursuit, it is not a litigation, but it is really occupying the major space in the docket. What is the reason behind it? One of the reasons is I have seen in every court, if I am not wrong, I think everybody has come across, a lot of writ petitions are coming for non-consideration of the representations. An approach has been made to an authority, and the authority is sitting tight over the matter or keeping that particular representation in suspended animation for all time to come. And the grievance is raised before the court in the writ. So it really requires a collective responsibility, both of the executives and the judiciaries. The judiciary definitely is there to impart justice, but also is an executive who has to really address to the grievances once it is raised to them. We cannot curb any access to a common man to reach to a court. I think any kind of obstacles or the hurdles, if it is created, that definitely is not ordained in the Constitution, which we have adopted as a people of the country. So access has to be done. Now the second aspect is that sometimes the access becomes too burdensome because of the cost being attached to it, and sometimes the access becomes too far as the courts are not in a close proximity of the area where he lives. It is really, when I depart from Calcutta and came to Odisha, this is really, I was surprised and I am really thrilled and overwhelmed to know that at least the Gram Nyayalayas are being established in the state of Odisha, in many of the places. That is really one of the very, I would say, the initiative which has been taken by the state and the judiciary in collective, that they have established the Gram Nyayalaya so that it can have an access to all the remotest place where the peoples cannot access to a main southern courts. So this is one of the very good, I would say, the initiative which has been taken, and definitely it also impacts the disposal of the cases also in a time-bound manner and in a very cost-effective manner. I have some suggestions which I have noted down, and I wanted to highlight those for your consideration in all respect. What I believe is that we have to strategize certain things in order to reduce the pendencies. The first and foremost thing which I perceived in this regard was the case and the court management. This is really essential to strengthen the justice delivery system. And the court must take up this responsibility of the case management, not only giving a timeline within which it is to be done, so that the speedy justice can also be ensured and the avoidance of the adjournment can be ensured. I should not be taken amiss, but I must, when I get the opportunity to speak in this particular occasion, I must say my experience, which does not appear to be very good in a speedy disposal system of the cases. When I came here, whenever the matter is listed before me, then there is a frequent adjournment which is sought from the other side solely on the ground that the matter is listed for the first time today to take an instructions. I said when the writ petition was served upon you, it says that 2 months or 3 months back. Then what constrained you not to take this instructions in the meantime? You had the enough time before this matter is taken. But this becomes a very routine and regular matter. If you take an instruction in a time-bound manner, then in that event, even if the matter is appearing for the first time, if the issues are of such which does not invite any dealing of or any dealing with the facts which have been adumbrated therein, so that can be disposed of on a very first day. It will not invite another day to come and then to dispose of. There is another thing which, when the learned Advocate General is here, I must intend to convey that what I find is that the cases pertaining to the state is being assigned on a daily basis to a different lawyers. On a Tuesday when the matter was taken up, there was another state additional government advocate who appeared. But if the matter is spilled over and taken up on Thursday or a Friday, there is another advocate who comes and says that it has been assigned. I think if it is assigned to one judge, one person, one lawyer, and to appear in that particular case, I think that will definitely avoid this kind of a recurrence aspect. So this is how the court case management we have to think about. Then the strict case management and the performance benchmarks must be enforced also in the district courts. When the courts adhere to the structured timeline and a disciplined hearing schedules and measurable performance standards, the cases progress without unnecessary adjournments on a procedural drift, and the lawyers and litigants spend less time and fewer recourses on repeated approaches or the appearances, reducing the overall cost of pursuing the justice. Then the second, which is also very close to my heart, that is the mediation, is an alternative dispute resolution. Why not? We should encourage all the litigants to go for a pre-litigation mediations instead of court-annexed litigations or a case-annexed litigations. Now, the legislatures have come in some fields where they have structured this pre-litigation mediations as mandatory before you approaches the court. I believe that in all the cases, if the lawyers, they encourage the litigants that why don't you go for a pre-litigation and just take initiative to resolve it. I think that's the greatest service one can give to a society. And I think the lawyers always are the front runner and the torch bearers. They have shown the path in this regard. The second aspect is the specialized bench. If the bench is adorned by a judge who has an expertise in a particular domain, and if those cases are listed before him, I think that will really help in reducing a large number of cases, because the time which would be consumed will be less for him in comparison to the other. So that's my one of the thought that that may be put in place to reduce the burden. The second thing is that we must acknowledge and embrace the technology which is now advancing rapidly. It has really created a paradigm shift from a conventional way of dealing with the papers, voluminous papers which are there, even very hard to lift and to be placed on the dais. And now we have gone to a paperless court. So we must also take up all the digital case management system, the e-court initiatives which have now I think the Honorable the Chief Justice of India as the chairman, executive chairman of the NALSA has also advanced. So we can definitely take forward that e-courts initiative that will definitely give a well-designed process automations, e-filing systems and video conferencing facilities, which can definitely reduce time and travel and travel burdens for the litigations while enhancing the judicial productivity. Then fixed timelines, if we can fix for the hearing of the matters or for disposal thereof, that can also be done. Then the artificial intelligence now is coming up, though I do not know, but it's my own feeling that it cannot substitute the human brain or the human intellect. It may be used as an effective tool to enhance the efficiency of the human, but it cannot substitute the human. So in that event, we can use the artificial intelligence, which can, in order to prioritize certain cases, which are really there, and the automatic automatic churning of the cases, finding out the batch cases, finding out the cases which involves the same proposition of law which is to be decided, so that they are listed before the court and they're disposed of in a no time or in a very less time. So that is also, we must embrace the artificial intelligence in this regard. We can also use the artificial intelligence for auto listing of the cases, so that it comes on a regular basis. Each cases are being addressed to, and the over and all, in order to ensure the reductions, we have to increase the judge population ratio also. We are having 20 judges per million, whereas the other developed country have more than 200 or nearly 200 per million. So this is also one of the factors which I feel will definitely not only reduce the timeline within which the cases are to be disposed of, will also be very cost effective. And above all, it is a justice which must be preserved and must be secured. Thank you for giving me this opportunity to do. Thank you.
Thank you, Your Lordships, for your enlightening address. Justice for him is not a verdict pronounced from a pedestal, but a whisper of understanding from a conscience awake. It must touch not only the letter of law, but the pulse of life. His philosophy of law, justice must touch gently, for law that cannot feel, cannot heal. Yes, ladies and gentlemen, he is none other than the 53rd Chief Justice of India, Honorable Shri Justice Surya Kant. His Lordship's commitment to tackle the massive backlog of cases, limiting adjournments in all cases, streamlining causeless system, leveraging technology for inclusive efficiency, reflects an unwavering dedication to enhancing judicial efficiency. It is my singular honor to invite Honorable Chief Justice of India, Shri Justice Surya Kant, our chief guest, to enlighten us with his visionary reflections and distinguished address.
Thank you. Thank you. Justice Harish Tandon, Honorable Chief Justice of the Odisha High Court, my esteemed brother and sister judges from the Odisha High Court, very distinguished former judges of the High Court who led this institution and this great High Court as an example, Shri Pitambar Acharya, learned Advocate General for the State of Odisha, Shri Manoj Kumar Mishra, Senior Advocate and President of the Odisha High Court Bar Association, Shri Shitanshu Mohan Dwivedi, Senior Advocate and Chairman of the Odisha State Bar Council, Senior Advocates and learned members of the Odisha High Court Bar Association and various other bar associations of CUTTACK and Bhubaneswar who are gracing this occasion. But most importantly, very respected senior advocates who have completed 50 years or more in practice and those who have been honored by the Bar Association today, Registrar General, judicial officers and other officials of the High Court establishment, senior officers of the civil and police administration, the Mayor Shri Subhas Singh, Mr. Vinay Tosh Mishra, IPS Director General, some of the very senior advocates to whom I really felt very honored when I found that they have grace this occasion. I salute you, all of you, sir. Senior judges of the High Court, Justice Pathak, Justice Sahu, and of course my other brother and sister judges, the members of the bar, ladies and gentlemen, my dear law students, friends from media. Thank you very much for inviting me for this felicitation event and also giving me this opportunity to speak on a topic which is very close to my heart, namely ensuring justice for the common man and what should be our strategies for reducing litigation, costs and delays. As always, it's a pleasure to be in Odisha, a land shaped by artistic excellence and great ancient kingdoms, a land which is honored in our national anthem by its sobriquet or nickname Utkal. All of you know Utkal being derived from the Sanskrit expression, and when you translate that, it says the land of elevated art and craft. That is, I think, a perfect fit of a little for a reason where creativity has long intertwined with character, where culture stands not as an ornament but as an inheritance. But beyond our venue, I am enthused to be among you all today in this landmark symposium, as I said, very close to my heart. When on 24th November 25, I assumed the office of the Chief Justice of India, a swarm of reporters surrounded me. My media friends are always there when I go, and I am very thankful to them. They ask sometimes very intelligent, very pertinent questions. So some of them, rather each one of them would definitely ask a question which is very common, that what is my vision? So of course many of them would expect that I will give very elaborate institutional blueprints that I am going to do this, I am going to do this, that's my planning. But probably to that extent I may not be very encouraging for them, because I have not said so many things except to say that the first goal I could verbalize is very simple, and that goal is to ensure justice for the common man. That is the mission I am carrying, and with your active support, cooperation, a collaborative approach, a commitment, I am quite sure that we will be able to march that difficult path and reach at the milestone. Everything else, my dear friends, for me, from reform to technology to ADR, flows from this single moral imperative. Yesterday I was in Jaisalmer inaugurating the West Zone Regional National Judicial Academy Conference. There also I spoke something quite similar, that the true test of our judicial system is not in its theories, but in the lived experience of the ordinary citizen. We reflected on how the rule of law acquires meaning when justice feels predictable, accessible, and humane. The discussions there centered around on a simple ideal, namely that every reform must ultimately lighten the burden on the common litigant, reduce uncertainty, and affirm dignity. Please keep these three principles in mind when I say justice to the common man, and these are the ingredients of that justice, namely the reduction of burden on the common man, reduction of uncertainty, and affirmation of dignity. The themes may have worn different clothes in Jaisalmer, but their heartbeat was the same. Today's symposium is most timely in confronting the two obstacles that frequently stand between the common man and the true justice. What are those two obstacles? One, the cost of litigation, and second, the delay in its resolution. So let us examine the human face of delay. Allow me to begin with a memory from my days as a young lawyer in district and high court. The days when I spent most of the time in dusty corridors than in air-conditioned chambers. One afternoon, I noticed an elderly farmer waiting outside a courtroom. He had a matter listed at such a number that it might come the turn or the turn may not come. It was already 3 p.m. So I asked him out of concern, as normally in part of the states, in our side, we sometimes call them as Tau or Taya or Chacha, whatever you, but normally we call as Baba. Why are you still waiting? Your case may not be taken up today. He smiled sadly and said, Beta, if I go home early, the other side will think I have given up. And that is what is a question must introspect each one of us. That moment has stayed with me for all these decades. For him, delay was not a docket statistic. It was a quiet erosion of dignity. And cost was not a legal expenditure. It was a financial winter he had to endure. Near Puri, there is a famous proverb, because we all and each one of you, as I could see when you were felicitating me, each one of you were remembering Lord Jagannath. So therefore, please remember, near Puri, there is a very famous proverb, and the local audience, they are very familiar with, and I'm quite sure that each one of you will be very familiar, but I may not speak the local dialect correctly, but if I remember correctly, they would say, Jete bele gote chota dari fate, bada kapda madhye khai diye. Means what? When a small tear appears in the cloth, when a small tear appears, even the strongest cloth will eventually give away. And that is the alarming bell for all of us. This is what happens to dignity when justice wavers. The right to dignity, our most cherished fundamental right, professed under Article 21, from which all other rights flow, is comprised, and it can be in a way compromised through 1,000 cuts in that cloth when the rule of law becomes tardy or expensive. In the spirit of avoiding such an unfortunate and untimely device of the hope and trust of that common man, that old man, I want to share some of my own nuanced ideas on how to tackle the two-headed beast that we are faced with, reducing both delay and costs for the common man in his quest for dignity. When we are addressing the backlog for clearing the pipelines, various innumerable suggestions have been given by brother Justice Harish Tandon, Honorable the Chief Justice. Very eloquently he has analyzed some of the reasons that are factoring from High Court to High Court and from institution to institution, whether it's the district court or the constitutional courts. Those reasons undoubtedly are very, very important to be addressed. But the point is that the most obvious starting point, of course, is the high level of pendency. across all the judicial forums, as I said, whether it is district court or the constitutional court. What is perhaps less obvious is that pendency is not just a number, it is an ecosystem. It clogs every level of the judicial structure, from the trial court to the constitutional court. And of course, as you know, a blockage when occurs at the top, the pressure only intensifies, it will intensify at the below level. So while I have said that this earlier on numerous occasions also, and today also again I reiterate that we must clear the bottleneck at the highest level. And the highest level is the constitutional courts. To my mind, therefore, the bigger challenge today is before the constitutional courts, the high courts and the Supreme Court, that how they address their areas and pendency. The reason is very obvious. Thousands and thousands of cases in the district courts are awaiting conclusion of the proceedings because the question of law, maybe a mixed question of law and fact, and maybe some substantial issues are pending consideration before the superior courts. Unless those are effectively responded with clarity, the matters in the trial courts will remain pending, and that continues to multiply the burden there. Several categories of long pending matters in the Supreme Court, often involving settling of law, are now planned to be conclusively disposed of. I can assure you we are working on it. We have some plan on it, that how in a phased manner some of the matters because of which there are huge pendency either in Supreme Court or because of our pendency the matters are pending in the Supreme Court or in the district courts. We are trying to prioritize those cases, and I am quite sure that with the commitment and dedication which my sister and brother judges in the Supreme Court have shown time and again, and the kind of support they have extended, I am quite sure that we will be able to address this issue, if not completely, to a large extent. And that will, to my mind, will help the high courts also to expedite the issues pending before them, and with a result and consequential benefit percolating to the district judiciary. But this entire issue that has been talked as a docket management in the past, now I have started saying it instead of docket management. Allow me to use a term, I am saying it system stabilization. Because when the top court gives finality, the others gain confidence. Therefore, it is not the docket management alone, it is the system stabilization. And we are quite confident that we will be able to successfully work on it. But the question will arise, which my brother the Chief Justice also pointed out in a way, we have the same strength of judges and the matters are also same. There is nothing like drastically reduction, and nothing drastically has been added also. That's in a slow phase. With passage of time, the matters are being added and we are trying hard to dispose of. That's a continuous process going on. So therefore, what we should think of, those tools or the mechanism which can really help us in addressing or in dismantling this sphere of pendency of cases, the areas as we call. So this, I personally feel that the alternative dispute resolution is going to be the only game changer which will help us a lot. And that is a part of my, when I say the system stabilization, that docket management, the second game changer will be the ADR. For that, I feel that mediation especially is going to help us a lot. I am quite sure that there was a point of time when the members of the bar had some apprehension, or I would say eventually it came out to be only a misconception that mediation might affect their practice. But actually it has not happened. I am quite confident that members of the bar also by now are very, very cooperative, and with, in fact, with their very active support and proactive role, that mediation has become so popular nowadays. All of you will remember a couple of months back when I was executive chairman of the NALSA, I gave this a kind of a national level mission, that mediation for the nation. For 90 days it was propagated at different levels, and believe me, the kind of response I have received within and outside the country. So many public sector undertakings, so many private institutions, including the private sector people, they have approached us requesting that their officers may be trained as mediators. They would like to open a mediation cell within their own organizations, so try to settle the matters amicably. Insurance company, banking sector, non-banking companies, so many people have approached us, and of course we are providing them training in phased manner, knowing our limitations of the trainer being available with us. But this I am only pointing out that how mediation is getting popularized, and it is going beyond the compounds of the court now to the corporate entities, their head offices. It has already entered. In fact, I keep on repeating this instance also, which I am sharing with you. In 2023, just about a little 2.5 years back, I received an invitation from the Federal Court Bar Association of Malaysia. They're the Supreme Court is the Federal Court. So their Federal Court Bar Association invited me to be the keynote address, to deliver the keynote address on the inauguration of an international mediation center in Kuala Lumpur. I expressed my little reservation to accept a private invite of the Bar Association, so I said I will wait that if I get a communication, some official communication, then I would like to come. So after a couple of days, I received a formal invite from the Chief Justice of the Federal Court for the same event, and I went there. I must share with you experience, because these are all pleasant experiences. These are all, the best practices at the global level that are taking place. I found that each and every member of the Federal Court Bar Association there in Kuala Lumpur was so actively involved in the event. They were so enthusiastic. They were so excited that they are going to establish an international mediation center to compete with any XYZ mediation center. And what a beautiful building. They ultimately, where the consultation rooms, the proceedings to be held, a record to be maintained, everything that was inaugurated on that day. That was the event where I carried a very strong message with me, that if it can happen in Malaysia, why it cannot happen in India, where we are struggling with so much pendency. And mind you, the mediation as such is basically an original idea coming from our culture. When panchayati system, sitting under a banyan tree, the elders participating, resolving the dispute. So the mediation as such, the original concept, now it has been structured, it has been codified. But as such, if you look into, this is our cultural heritage, and therefore I thought that we must try to popularize it. So while in couple of last few months, when there has been a lot of a movement for mediation, I can share with you that I have seen the embittered families, they dissolve their disputes through reconciliation. Yesterday only I was talking with the Honorable Chief Justice. We were talking that it is sometimes very tough to persuade the parties in partition proceedings or in family disputes sometimes, because once there is some ego issue or some emotional setback or some kind of emotional hurt to them, they don't agree to it. But I was sharing a successful story of West Bengal only, where the family fighting for last 4 decades, eventually in my court they agreed for mediation and the dispute has been happily resolved. So we have to create these instances. These instances will be created from the table, from the brief, from the office and chamber of each member of the bar. And believe me and trust me that wherever you will be able to succeed in mediation of one matter, it is going to generate you several matters coming to your chamber because of your goodwill in profession. Similarly, in commercial disputes also, now the parties are very keen and they want to resolve their disputes in a country with a promising growing economy, where the commercial disputes are likely to spread, where the new startups will come where they might have some fear of their investments, and in the event of dispute, how they are going to protect their investment in the country. We need to provide a very robust system which can respond to commercial disputes immediately. So two-tier system. One, where we can introduce a medium as one of the mechanism where the parties can immediately resolve their dispute with very low cost and with a win-win situation both sides. The second, we need to have a predictable commercial court system where the dispute will be resolved on merits, but with predictability and with a dedicated timeline. So these two things we need to evolve for the purpose of commercial litigation, so that at least our country as nation, we are benefited, and in terms of a very responsive legal system, we do not lag behind in any other, as compared to any other jurisdiction on the globe. I can sometimes, a question arises that what stage the mediation should be tried. One, every experienced judge in district courts or in the high court, they know how and when the matter is ripe for the mediation. Similarly, members of the bar will also immediately understand what is the right stage when their client can be asked, persuaded for mediation. Because this will depend upon case to case, one-to-one basis and case-to-case basis that you will have to really work on it. But never feel that mediation, if at the preliminary stage has failed or at the beginning it has failed, it will never succeed. These are also, I have very wonderful, successful examples where parties failed in mediation once, twice, thrice, but eventually in the fourth attempt, fifth attempt or sixth attempt, they succeeded and they resolved their disputes. So we have to, 3-4 things for mediation we need to keep in mind. One, parties must understand its value. So the first thing, that is a responsibility that comes on the bar and sometimes on the bench also, rather borne both on equal side, that we must try and persuade the parties to understand the value of the mediation. What is that value? Absolutely low cost effectivity. Second, timely adjudication. 3, win-win situation. 4th, a complete closure to the future litigation. Once you give these incentivized ideas to a consumer of justice, I am quite sure, and you will also be equally sure, that he will definitely consider it a very favorable modicum of resolving his dispute. Second, some government officers are also there, but most importantly, learned Advocate General himself is here. And wherever the government litigation comes, I personally feel that the government departments must shed their reflexive habit of filing appeals. Unfortunately, sometimes the bureaucrats are also maybe right. They feel that if I don't file the case tomorrow, after 5 years, after 10 years, somebody will open the file and hold me accountable for it. That why did I accept this judgment? Why didn't I file the appeal? This kind of psycho-fear is because of the individual accountability we start fixing on it. It should be an institutional accountability. The government should take a policy decision as a part of the litigation policy, that where up to this stage when you have lost the case, say for example, if you lost a case at 2 courts consecutively, assuming the judgment is erroneous, assuming that you might succeed in the 3rd appeal, but still your policy framework can say we will close the litigation here. Or at 3rd stage, why don't you say that all right, I have lost it, but now I will try for a mediation. So the government's flexibility on mediation part, particularly why coming to it, that government must come out with a proactive approach that we would like to settle the disputes, and this accountability business should be resolved within the government functioning. I am quite sure there are many appeals not based upon legal principles, but these are filed only because of the institutional anxiety. Therefore, this accountability framework need to be revisited by each state and by all the stakeholders. The third thing, that is for my dear members of the bar, whom I have been really depending upon throughout the country, I'm sharing with you my biggest strength throughout the country are the members of the bar. And that's why on your invite I'm here. You see, you have to develop that mediation culture as a part of your professional skill. And this can happen once we avoid, normally what will, the practice is that when the litigant comes, we advise him, and rightly so, that this is your cause, and for that you can go, say for example, you can go to Motor Accident Claim Tribunal, you can go to civil court, you can go to a reference court for compensation, or you can go to any constitutional court. That is what perfectly legal advice we always give, and there is nothing wrong in that. That's part of your professional ethics, and you must continue with that. But while giving that advice, if you also tell the litigant, look here, we are filing your case, but we will take a chance of compromising at the earliest through mediation, so that whatever benefit you get today will be much better than what is going to be granted to you after 5 years. And that client will also understand the implications of that passing of decree might be easy, execution is very difficult task in the system. So that is part of a professional culture for which the stakeholders in the Bar Council are here, the stakeholders in the Bar Association are here. My young friends, particularly in the bar, you need to cultivate that culture. When you will go to US and when you meet the members of the bar, you will find that this is an integral part of their professional ethics, that they will advise a litigant to go to mediation. And that's why in US, you will find out a large scale of litigation is settled before it formally enters the courtroom. That is, and the professional, the bar is engaged, the lawyer is engaged, but he, instead of going to the direction of the court, he goes to the direction of mediation. I believe, I'm quite sure that now with the Mediation Act having come into force, and on 8th of November, some of you, if the Legal Aid Council or paralegal volunteers, and some of those who were present in the 8th and 9th November 25, in the annual meet of the National Legal Service Authority, Honorable Prime Minister inaugurated that on 8th November, and Community Mediation Compendium was formally launched on that day. That was because I was chairman of the National Legal Service Authority, and we have formally launched the Community Mediation Compendium we have released. Through that procedure which is laid down there, it's a very comprehensive guidelines are laid down how to go for mediation in the rural area, in the different communities. I am quite sure that with the publication and with the circulation of that community mediation platforms, you will really take the mediation to the to the villages, to the streets, and to the last man in the street, where I'm confident that mediation will be accepted as a very happy and a acceptable at the first instance a mode of resolving the amicable the dispute. The most important thing of mediation, please, is it maintains the social fabric, social harmony, human relationship, and it does not allow a party to feel defeated. So that's extremely important service to the society when we as professionals render. We must also continue with our old tried and tested weapon of Lok Adalat. I think day before only, the National Lok Adalat was held, the annual, and the kind of facts and figure coming, these are quite encouraging. I am quite sure that what the traditional mode that we have adopted many years back will continue to help us in resolving the disputes. Now the question of technology. Chief Justice Harish Tandon very eloquently explained that how can technology, if infused properly, can help a lot, but at the same time he also expressed his apprehension that AI cannot be substitute. I entirely agree with that. AI should not. It's a tool, and its value depends entirely on the wisdom with which it is used. But remember, during pandemic, when the entire world, the legal system was shut down, it is the Indian courts only that were functional. Because that experience of running the online courts, virtual hearings, even filing through emails or through using e-technology, that really made us to learn various lessons, including that technology can collapse distance. A person sitting, a lawyer sitting in the subdivisional court of Odisha at the farthest corner could file a case in the High Court. A lawyer from there who could appear online and could argue the case. We experienced, myself experienced, the lawyers from different parts of the country appearing online and arguing cases before the Supreme Court. So that was a very great experience, a very pleasant experience by the legal fraternity to see that technology can collapse the distances. It can dismantle the geographical barriers. One, it democratizes the access. I'm using this word. It ensured that there is no monopoly of particular set of lawyers or associations while appearing. Supreme Court is open for all. So therefore the lawyers from any district court, from the High Court or from anywhere, they could appear. So was before the High Court. So in a way, it gave an equal level opportunity to the members of the bar to appear before different forums. The third thing, it accelerated the procedure because everything through technology. So therefore the procedural impediments were effectively addressed by it. So that lesson we have carried forward. And that's the reason that we have infused technology now in so many processes. Digital service of summons, electronically tracked notices, all these are being used for elimination of the delays of months in effecting service. Earlier process server, the process was very uncertain. Now the things are taking place. E-filing is now there. All these factors have really helped us a lot. Yet we cannot afford to forget, as rightly pointed out, that technology comes with its own shadows. In an age of deepfakes, digital arrest, we as courts cannot afford naive optimism, and equally a reform that excludes the poor, because I am talking of digital distance, digital discrimination. If it excludes the poor or the elderly or the digitally unfamiliar is not a reform at all. There are people who cannot use, they do not know how to use the digital technology. If they are excluded in the stream of development, that will also not amount to reform. Therefore, we have to ensure that technology is used in such a way that it follows the principle of inclusivity. And otherwise, it will amount to regression. And that's why I always maintain that technology must remain a servant of justice, not its substitute. It should amplify human judgment and not replace it. So therefore, with these two kind of caveat that we can use the technology, and that's going to help us a lot in early disposal and in hammering the pendency. Lastly, any serious discussion on reducing delays and strengthening access to justice must acknowledge its intrinsic dependence on adequate infrastructure. Chief Justice HARISH Tandon rightly raised this issue. Unless we will have infrastructure, we cannot do anything. If we want to increase the courts, where are the officers going to sit? Unless we have the bar rooms, unless we have the basic amenities, unless I have a separate washroom for my daughters and sisters, members of the bar association, how are we going to perform? Therefore, the infrastructure is also an important issue. And for that, I am going to request all the Honorable Chief Justices to take up the issues wherever we are lacking in basic amenities with the state governments, and of course I will also take up with the relevant quarters to ensure that in a periodical manner all these facilities are made available to us. A system where the executive, legislature and judiciary, if they do not move in harmony, what will happen? It will look like, it will resemble like a tricycle missing a wheel. a tricycle missing a wheel, where the rule of law cannot be balanced. There is no question of traveling it further. But if all three are harmonized and they work collaboratively, I am quite sure all the infrastructure issue can be resolved. All other related facilities can also be provided. For example, for technology, I must acknowledge and I must appreciate. When I took over as Chief Justice of India, I found that more than sufficient budget allocation is there. It's only that our proper and optimum utilization of that fund for the purpose which can be effectively help us. That otherwise there is no dearth of funds for that. I am quite sure the other issues will also be equally and effectively taken up. Say, for example, that matter I have already taken up, that specialized courts, like in the sphere of family courts and commercial we have seen, and in some of the criminal, you must have seen that in these two fields, the special courts have really helped a lot. But I believe that in some of the very heinous kind of crimes which are sometimes a threat to the very fabric of the society or to the society at large, under various statutes which are special statutes. For trial of those cases, it is very imperative that we have dedicated courts which are exclusively dealing with those matters only, and where the trials can be concluded in a time-bound manner. That will be a very fair approach to those who are actually found to be guilty of committing this kind of offense, and to those ultimately against whom nothing is proved. So it is something balancing the right of both sides, that we need to have these kind of specialized courts. And I am quite sure that infrastructure, when we talk of it, must not be seen as an expenditure by any stakeholder. They are not an expenditure. It is an investment. Investment in the system. When we construct courtrooms, when we appoint staff, when we use technology, or when we provide basic amenities to the members of the bar or to the staff, I am quite sure these are not luxuries. They are all skeleton of a justice itself. And when we strengthen these amenities, these basic amenities, we strengthen our republic. Ladies and gentlemen, people often speak of the vicious cycle of pendency. You must have read various articles. More cases leading to more delay, leading only to the more frustration. But my mission is to reverse this, a kind of this statement or a negative impression that is being created by about the justice delivery system. By reversing it, I want a virtuous cycle, and in that virtuous cycle, when pendency falls, trust rises. When trust rises, respect for law deepens, and when respect deepens, disputes diminish. And that should be the cycle that we will follow in future. While concluding remarks, allow me to return to the land that so graciously hosts us today, the great land of Odisha, a region whose history reminds us that great endeavors have always succeeded through collective effort. Its heritage, from ancient maritime trade to enduring artistic traditions, shows that progress is never the work of a solitary hand, but it is always the cumulative strength of many working in unison. Similarly, our justice system may be like to a chariot. The bench, the bar, the administration, and the citizens are the four wheels. If one even refuses to move, the journey halts. Let us resolve collectively to push it together. I may not be accused of saying that while sitting on the dais when the president of the bar or the chairman of the bar council were speaking, they had talked about certain requests or demands, whatever were there. I don't want to say that I have not heard, partly I have heard. All these issues will be in due course of time resolved. I am quite sure that with your cooperation and with your help, the things will be taken care. I am very hopeful, confident on my agenda of providing this timely justice to the common man. And as I said, I repeat my appeal in a very passionate manner to all of you that this can only happen when we work together as a team, as a family. The entire legal fraternity has to have this motto as their principal goal. This may be a beginning, but once we begin, then we know that we will be able to reach the destination. आप सब लोग जो थोड़ा बहुत उर्दू का लफ्ज़ों को जानते हो और जो कभी शेर व शायरी कभी आप सुनते होंगे ध्यान से, तो एक कवाली आपने बड़ी फेमस, वैसे तो वो गज़ल भी थी और कवाली भी गाई थी उस्ताद नुसरत मियाँ ने। उसमें एक शेर आता है, मैं अक्सर उसको लास्ट में सुना देता हूँ और वही सुना करके मैं आज भी अपनी बात मत करूँगा। ये इश्क नहीं आसां बस इतना समझ लीजिए, ये इश्क नहीं आसां बस इतना समझ लीजिए, ये आग का दरिया है। और कुछ लोग कहते हैं डूब के, पर मैं कहता हूँ तैर के जाना है। थैंक यू वेरी मच, थैंक यू फॉर इनवाइटिंग मी। जय हिंद, जय भारत।
Thank you, Your Lordship, for such an in-depth and compelling yet comprehensive address. Personally, as a young advocate, it is deeply inspiring and moving to hear you say that the bar is your strength. The bar and bench stands united in profound gratitude to Your Lordship and appreciates your predisposition towards cultural continuity embodied in the Constitution's promise of merit and resilience. Your Lordship's words reflect your vision for revolutionary and sustainable reforms and instill a renewed faith in the judicial system. Your Lordships, I would like to emphasize that apart from this filled auditorium, thousands of participants have joined us live via YouTube broadcast, bearing witness to this momentous occasion from across the nation. As we bring this august and insightful symposium to a close, I invite Shri Siddharth Das, Advocate and Vice President of High Court Bar Association, Orissa, to propose the vote of thanks.
Honorable Chief Guest, Honorable Sir Justice KANT, Honorable Chief Justice of India, Honorable Chief Speaker, Honorable Sir Justice HARISH TANDON, Honorable Chief Justice of the Orissa High Court, Honorable Judges of the High Court of Orissa, Sri Pitambar Acharya, Advocate General of the State, Guest of Honor, Sri Prasanna Kumar Pari, Deputy Solicitor General of India for Orissa, Sri Sitanshu Mohan Dwivedi, Chairman of the Orissa State Bar Council, the Guest of Honor, Sri Manoj Kumar Mishra, President of the Orissa High Court Bar Association, and Mr. Abhijit Patnaik, Secretary of the Orissa High Court Bar Association, Senior Advocates, members of the Orissa High Court Bar Association, esteemed guest of honors, distinguished members of the bar, respected dignitaries, respected senior advocate who have felicitated today, ladies and gentlemen. It is my singular honor to propose the vote of thanks on behalf of the High Court Bar Association Orissa on the occasion of this meaningful and timely symposium on ensuring justice for the common man, strategies for reducing litigation costs and delays. I, Siddharth Das, Vice President of the Odisha High Court Bar Association, therefore present the vote of thanks on behalf of everyone. First and foremost, we express our deep gratitude to Honorable Sir Justice Surya Kant, Chief Justice of India, for gracing his event as the chief guest. Sir, your presence and your insightful thoughts have enriched today's deliberation and inspired us to reflect deeply on the constitutional values we cherish. Our heartfelt thanks also to Honorable Sri Justice Harish Tandon, Chief Justice of Odisha High Court and today's Chief Speaker. Sir, your keynote address has shed light on the cost being imposed on the litigant and the delay in the judicial process, and today deliberation has provided impetuous clarity to everyone. You have been inspiring us since the beginning, and your insights have been always enriching. We further extended our sincere appreciation to our guest of honor, Sri Pitambara Acharya, Advocate General of the Odisha. Sir, you have always been inspiration and a guiding light to the bar. You have always endeavored to further the events and extended support at all times. And further, we would like to thank Sri Sitanshu Mohan Dwivedi, Advocate and Chairman of Odisha State Bar Council, for gracing the occasion. Your thoughtful observation and perspective have added depth to our discussions. I also take this opportunity to thank Sri Manoj Kumar Mishra, Senior Advocate and President of the High Court Bar Association, for presiding over today's function and for his leadership in organizing this symposium. Special word of appreciation goes to our whole executive body of the Odisha High Court Bar Association and the entire organization team, whose dedicated effort and endeavor have made this event a grand success. We are equally grateful to all the members of the bar, invited guests, print media and electronic media, law students and participants who have spared their time to join us in the cool morning. Your presence and engagement reinforce the relevance of today's theme. Finally, your thanks to the staff, volunteers and technical teams who worked tirelessly behind the scenes to ensure the smooth conduct of this program. On behalf of the High Court Bar Association Orissa, I once again thank each one of you. We look forward to more such enriching interacting in the future. Bande Utkala Janani.
There is a small announcement with the permission of the guest on the podium. Our President, sir, has arranged a lunch for all advocates and all law students and other dignitaries in the High Court premises. Please go and enjoy your lunch over there.
Thank you, sir. With the kind permission of the Honorable Chair, may we now conclude this august gathering. This symposium formally comes to a close. I request everyone to kindly rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request the guests to not leave the auditorium until after the dignitaries exit the stage.
On behalf of the High Court Bar Association, Orissa, thank you all for your gracious presence. Have a pleasant afternoon. Jai Jagannath. Lunch is served in the High Court premises. Please proceed for the lunch to High Court premises.